My name is Michael Young, and I'm a lawyer in Texas who handles will contests. In many, if not most, of the will contests that I handle, there are allegations of undue influence. Well, undue influence is a legal concept that says that a will is not valid if it's not the product of the mind of the testator, that it's really not what they wanted with their free will. Instead, it's the product of somebody else's threats or manipulation, and it can be overt, just straight up physical threats, but usually it's much more subtle. So, what are 5 red flags that I would look for in a will contest for undue influence? Well, one would be a sudden unexplained change. If a long existing plan is changed dramatically, in favor particularly of someone who just happens to have access to the person in any given time. And it's just something that doesn't feel right. Second is isolation and gatekeeping. The person who benefits from the will change had access to the testator and could control other people from reaching them, screens their calls, listens to their calls, has control of their phone, only allows certain people to visit, takes them away somewhere else, and has them do a new will when they're not around their typical family and friends. Third, the beneficiary is deeply involved in the will making, and that may be that they arrange for the lawyer to make the will. They drive them to the lawyer's office. They arrange for the payment of the legal fees. Without them, the will would not have been changed. There would not have been the lawyer appointment. And even more often these days, I don't even necessarily see a lawyer involved. They either draft up the document themselves for the testator to sign, or they go onto Rocket Lawyer or LegalZoom or one of these internet will places, and they set up an account and they fill out the will they want as they want the testator to sign it, and then give it to the testator to sign. And then the testator doesn't have the advantage of having independent legal advice. Maybe they even have a long-standing relationship with a lawyer. They don't have the benefit of getting their advice. And maybe a lawyer had done a will for them years before, and that lawyer is still practicing. Why didn't they go to that lawyer? Well, the reason is because the person who's benefiting from this will doesn't want them to have that. So they're in control of the drafting and oftentimes the execution of the will. And then there is dependency, which is much like control. The testator, the maker or the signer of the will, is dependent upon this person, maybe for going out and getting their medicine, taking them out to medical appointments, getting their food, taking them out to see friends and family. Just many ways that there could be a level of dependency, and there could be the threat of, I'm not going to keep doing this for you unless you make a will benefiting me. And then secrecy. The family members or the people who were the long-standing beneficiaries, don't know of a new will. All of a sudden, this person dies and this new will pops up out of the blue that no one had any idea about that. Those are 5 of the red flags. There could be many other ones. And it doesn't mean that a will is bad just because 1 or 2 of these show up, or even more. Nor does it mean that a will is good just because these 5 aren't present. But these are just things that I would look at, and that a judge or a jury would look at to evaluate whether a will is really reflects the wishes of the testator, or really whether it reflects the wishes of somebody else and is the product of undue influence. If you're involved in a Texas will contest, feel free to give me a call and we can talk about your case.